A UNUM Bacterial Skin Infection disability claim termination upheld by the court. Just drives me nuts, doesn't it? After 2 years of payments, many disability carriers or plans are required to determine whether or not you can perform the duties of any gainful occupation for which you are reasonably fitted. Now, generally, the disability carrier will review your medical records, and they are going to determine that you are able to engage in at least sedentary work. And they will argue that you are capable of doing work in a sedentary capacity based on the skills that you have learned in your past work that can transfer to any sedentary occupation. Now, in determining whether or not you can do that sedentary work, they have to take into consideration all of your disabling medical conditions, both individually and collectively. In the recent case of Moore versus UNUM, the court unfortunately upheld the termination of benefits because of her inability to walk or stand for a period of time as the result of her diabetes. And what they basically said is, yeah, well, you've got those problems, but they don't prevent you from doing full-time sedentary work, notwithstanding the fact that you may have difficulty walking from the car to the office building. The court also approved UNUM's reliance on the Social Security judge's finding that she had the residual functional capacity to perform sedentary work. That came back to bite her. So understanding the terms of your disability policy are key to keeping your disability benefits. When the terms of the policy change from an inability to do your own occupation to any occupation, you have the burden of proof. All the carrier has to do is to show that you can do sedentary work based on your education and work history, and that you have skills that will let you work in a sedentary capacity. As a matter of lessons learned here, and I'm not criticizing her or her attorney, but I would have potentially gotten a functional capacity evaluation to determine her ability to do a sedentary job. I would have potentially had an independent medical evaluation by a physician of my choosing to adopt the findings of the FCE. I would have had a Social Security attorney write a letter explaining why she may have gotten Social Security disability benefits at step 5 because age was a factor when age is not a factor in a disability insurance policy generally. And then I would have tied it all together with a vocational opinion. I think that you have to anticipate reasons why a disability carrier is going to deny a claim. When you get the notice of denial, you need to anticipate what proof is going to be required that would potentially convince a judge to reverse the decision. You've got to develop that, and you've got to consider what evidence in turn a disability carrier like UNUM is going to come up with in response to your appeal. Obviously, it takes a team, and I would strongly suggest that you work with an experienced ERISA disability attorney to get the disability benefits you deserve. Call me today at 727-894-3188 for a complimentary consultation.